Bom dia a todos e a todas. É com muita alegria que nós iniciamos mais uma sessão de grandes debates nesta semana, que foi organizada com muito carinho, né, e com muita dedicação pelo Departamento de Direito Público da Universidade de São Paulo. Eu sou a professora Juliana Domingues, estou aqui acompanhada do professor Gabriel Lochagin, da professora Magali Eben, que vem aqui nos prestigiar com todo o seu conhecimento, com as suas principais pesquisas, que são pesquisas que estão na ordem do dia, pesquisas que vão trazer para nós boas reflexões, inclusive, para os temas que nós temos hoje em discussão no nosso país. E não sem razão, foi por esse motivo que o tema definido para o dia de hoje é o tema que envolve the UK Approach to Regulation in Digital Markets. Os mercados digitais, eles têm sido foco principalmente, né, das pesquisas dos nossos acadêmicos dentro de diversas áreas jurídicas, então é um tema que também é bastante transversal, mas do ponto de vista regulatório, ele fica aqui embaixo de mim, do professor Gabriel, e que temos também orientado nessas pesquisas, que temos enfrentado aí os desafios dos debates que têm sido desenvolvidos aqui no nosso país, e ao mesmo tempo, né, oportunizar essa visão maior, mais holística e internacional, ela é bastante interessante. Por muitos anos, a nossa legislação, ela teve muita base, né? Eu digo até pela legislação de defesa da concorrência, a 12.529 de 2011, teve muito baseada na experiência internacional. E agora nós estamos falando de um mercado que é um mercado diferente de todos os mercados que nós estávamos acostumados a lidar, né? Os mercados digitais, eles têm essa característica, e é por isso que é tão importante trazer também essa perspectiva internacional, e não poderíamos ter uma pessoa melhor aqui com a professora Magali Eben, com todas as suas experiências, né? E também que tem feito pesquisas que são referências mundiais. Professor Magali, I am switching to English, okay? I was just saying good words about your work, about your research. I think it's a very good opportunity, as we have here more students from the university, to share a little bit. The fact that for us it's very important to understand a little bit more and go further the studies that we have in US, in UK. In this case today we are going to talk about the UK, EU. So for us it's a very important moment under the scenario that we have in Brazil, especially because we have ongoing discussions about those topics. So thank you so much for sharing your time with us. Thank you so much to be here with us. I think it's also an opportunity for them to keep in mind that next week she will be with us inside the university. So you just need to take this opportunity. And I would like also to thank Professor Gabriel, who is doing an amazing job. It's the best partner I could have inside the university. Now I know that my friends, they will hate me, but thank you so much, Gabriel, for being so nice and to be this great friend of mine. So Professor Gabriel would like to say some words to Magali before we gave the floor for her.
Sure, thank you very much, Juliana. Good morning, you all. It's very easy to be your friend, actually. You make my job very easy. It's a true honor for our Department of Public Law to sponsor the trip of Professor Magali to Brazil and our university. I think it's another great opportunity to discuss antitrust law with a very talented scholar from abroad. We have been doing this work, bringing our students closer to antitrust law with many experts, and we thank you a lot for helping us in our mission to expand the antitrust culture in the legal formation of our students. We are waiting eagerly to listen to your presentation, Professor Magali, so I would just like to finish this introduction by saying how thankful we are for you being here with us.
Okay, I think that the Zoom just froze Professor Magali. Maybe she can just turn off and turn on in between. I would like also to say that on Monday, we are going to follow this discussion in a broader way, also including EU. And it's a partnership with the IDP Institute in Brasilia. And on Tuesday and Wednesday, we are inside the University of São Paulo in campus Ribeirão Preto with Professor Magali. In fact, we will have this now our 5th edition from the Economic Law Seminar. And we are going to have also different professors from Brazil, Vinícius Klein from Federal do Santa Catarina, from the Federal do Paraná, and Professor Patrícia Sampaio from FGV Rio, and Professor Nicolas Ingales, who is now hosting also another event with us. And in fact, Nicolo, he participated from our 2nd edition online, because at that time he was living in Leeds, and now he is also part of the FGV team that works with topics related to competition, innovation, and technology. So we are just waiting here now that Professor Magali can join us again and coming back to this session.
Yeah, she wrote in the group that she will come back soon. I think she's just trying to reconnect. But just to expand on what you were saying, Juliana, I think you're doing a great job in bringing our students so close to antitrust experts. And this has happened this week in many places, and I'm sure our events next week will be as great as those in this week were.
Yeah, I'm sure about it too. And it's also an opportunity for us to share a little bit the work we are doing inside the academic society competition. And Academic Society for Competition Law, Ascola. I am the head of the chapter with Professor Vicente Bagnoli here in Brazil. But Magali is, in fact, much more involved, as she's also from the board of Ascola. So for us, it's also an opportunity to share to Magali the universities that we have that are still doing this really tough job that is making antitrust more popular in Brazil. We know the importance of our agency, just like CADE is very famous outside Brazil. And we need to also share what we are doing in terms of academia. And this is something that it's a problem for us, because the majority of our studies and researchers are in Portuguese. So for sure, it's a limitation for them to know what we are researching and our thoughts. But besides that, I think the fact that we don't have so many professors and researchers searching for topics and very focusing the research in antitrust issues, it's bring us this space that must be fulfilled with professors just like Magali. There is a very young and a rising star as academia, not in UK only, but worldwide, to know a little bit more about our job here. So that's why I'm very happy to have this, support from our university, the support from Professor Gabriel, and I'm sure after these conferences, we will have much more students, at least curious about the topics we are discussing here. So I'm glad you are back, Magali, and the floor is yours.
Hello there. Sorry that I dropped off, but I am back. Perfect. As you now have had a long introduction to who I am, I think I can just skip ahead and say that I'm really, really happy to be here with you all in Brazil. And I'm actually quite excited to talk about the UK's approach to digital markets regulation, because I was reading up on the fact that you're thinking about going forward with regulation, the proposal for a bill and so on. So I'd be really curious to hear what the plan is for an approach here. So to start with, a little bit of background, I suppose, about me, which is that I am an European Union citizen, but I live and work in the United Kingdom, which for a few years now is no longer a part of the European Union. And although there are a lot of downsides, in my opinion, to the fact that the United Kingdom is no longer part of the European Union, one of the positives or the interesting evolutions has been that the United Kingdom has come up with its own bill for regulating digital markets, which is different from the one that they have in the European Union. And so there's an opportunity to compare really the different approaches that they have. And that's what I want to do with you today. Because I'd be really interesting to see what you think, which approach is better, what you think would work in Brazil. So really, the story starts years ago, just like everywhere around the world. Everybody started getting concerned about the power of the big tech companies. And the European Union and the United Kingdom had in 2019 these reports by experts, academics, and people who are engaged in regulation and enforcement, who set out a list of the reasons why we were worried about digital markets. The United Kingdom is proud that they were the first, but it was only a month apart, right? So in March 2019, the United Kingdom had a report of experts on digital markets, and in the EU in April 2019. And really, these reports were very similar, looking at the same problems. And there are quite a lot of problems that people saw with digital markets, but I think some of these are familiar to you. So there was concerns that the companies like Google, Amazon, Facebook, Microsoft had a lot of power, but that the power might be a little bit different from our normal understanding of dominance. So here it's not just about power on a particular market, but these companies have positions across different products, across different markets. If you are a company, for example, and you want to sell products, you are likely to use a shopping platform like Amazon. And the question there is Amazon having dominance in one market, or is it in fact having a position of power between businesses and consumers, which is different from our view of dominance. That makes it a little bit more difficult to bring an abusive dominance case. But there were other issues. Cases in Europe against companies like Google, they existed, right? We had abusive dominance cases, but they took years. So if you spend almost 10 years on a case, then by the time the case is finished, it has gone through all the decisions, all the appeals, the market might have completely changed. And so it really felt like the competition authority was always running after those big companies. And by the time a decision was made, the company had already changed its conduct. And so those were some of the procedural problems. I think in Europe, there is also an impression that the problems were not just about exclusion. So not just about harm to competition in a way that creates inefficient products, but that there was a bigger concern in a way about inequality and the distribution of value on the internet. So who gets to be the one who wins on the internet? Who gets to be the one who gets the benefits of engaging with the internet? And it's not as easy to show how that translates into law, but I think there is a broader feeling about, the internet has become unfair. There are not as many chances. And I think that's an important feeling that you find everywhere in Europe. But what I think is interesting is that in the European Union adopted a Digital Markets Act, which is very specifically not behaving like competition law. There are no references to market power. There's no references to harm to competition. A company cannot defend its conduct. But in the UK, the new digital markets bill that we have, it refers to competition. It refers to market power. There is an opportunity to defend yourself if you are a company. And so clearly there is a different rationale, a different logic between what is being done in the European Union and what is being done in the United Kingdom. And I think that's interesting. And so I want to talk a little bit about it. So in the Digital Markets Act, and this is all going to get very confusing. DMA is the one in the EU and DMC is the one in the UK. So I will just say the EU bill and the UK bill so we don't get confused. In the EU bill was adopted already for a while, and the first actions have already started. The UK bill was only recently adopted, and we don't know yet what the first actions will be. What they both share in common is this idea that instead of doing one-off conduct investigations, under both the EU bill and the UK bill, the competition authority, because still the competition authority is in charge, the competition authority is going to select particular companies that it will identify as being designated, so as being part of the bill, which means the bill only applies to the companies that have been designated. In the EU, this has already been done. So we have done the designation part, and if you won't be surprised to hear who has been designated. So obviously, Microsoft, Google, Amazon, Facebook, but also Booking.com, so the hotel booking platform, which is an EU platform. ByteDance, so TikTok, has been designated. And what is interesting about the EU's designations is that you don't just designate particular companies, you designate particular products of those companies as being important products, important services. So what happens with the EU bill is that once you are designated, suddenly loads of obligations apply to you. The European Competition Authority, the European Commission, does not have to go and check whether you have done anything wrong. The moment you have been designated, you have to do loads of things. And this includes like interoperability between your services, and includes particular restrictions on data sharing. You need to get heightened consent for data collection. You cannot prefer your own services over the services of other companies that are using your platform. So this is very similar to a case we had in Europe a couple of years ago, where it was said that Google, for example, cannot show its own partners and its own services the highest in the search engine. So something similar on Amazon would be if you have Amazon products or Amazon supplied sellers, they cannot necessarily be privileged over other sellers and products. So this is one of the obligations. So in the EU, if you are now designated, you suddenly have to comply with lots and lots and lots of obligations. And they apply without an investigation. However, there are some kind of negotiations going on in the background between the European Commission and these companies about what is considered to be a good way of applying the obligations. And so a lot of people, I think, at the start of this thought that, you know, there was a bit of a conversation going on between the European Commission and these companies. I think that conversation has died recently because an example is that Facebook offered a particular solution for data collection, and the European Commission didn't like it and immediately started an investigation to say that the Facebook has broken its promises under the Digital Markets Act. So I think the negotiation died very quickly. So in the EU, although there's was on paper some kind of opportunity for kind of compromise, I think compromise is gone. And I think that's an interesting one. I mentioned it at a talk in previous days. It's where the negotiation has died is on something we call the pay or consent model, where Facebook said, okay, we will stop collecting as much data about users, but in exchange, in the European Union now, people who don't want the data collected need to pay. So you pay for Facebook a monthly fee. And the European Commission says this is not a good proposal. And instead of negotiating on what would be a good proposal, it has said they will fine Google for non-compliance. This is what happened in the EU. But the UK is very, very different. Okay? UK always likes to say it is the most rational, objective, economically inspired, well-balanced, kind of country in Europe. And I think this is why the bill is different. Whether it will work is a different question, but there are a few reasons why it is different, a few ways. The first is that the objectives of the bill in the UK are on paper different from the objectives of the EU bill. So the objectives of the EU bill are very vague. It's fairness and contestability. So really in the EU, it's about redressing imbalances in power on the platforms and about, to some extent, making it possible for companies to fight and become an alternative to the existing platforms. Fairness and contestability. In the UK, there are three more specific objectives. So you've got fair dealing, and fair dealing is defined very clearly as reasonable terms between a platform and its users. Fair dealing, open choice. Users need to be able to choose easily, quickly between the platform and its competitors. And thirdly, we have trust and transparency. So this is, I think, not so surprising. It's the idea that platforms need to give enough information, transparent information for users to be able to know exactly what price they are paying, what terms they are getting, and to be able to make a better decision on whether this is the service they want to use. Another important difference, and probably the most important difference, is that the EU bill sets out a long list of do's and don'ts, a long list of obligations and prohibitions. The UK bill does not do that. What the UK bill does is say the competition authority can, after it has designated a company, choose to impose obligations. Right? So remember, in the EU, the moment you were designated, the obligations in the law apply to you. In the UK, the authority can choose to impose them on you. So it is not automatic that if you are designated, you need to comply with all of them. And the bill gives us examples of things that the authority in the UK can impose, and they are actually very similar to the EU. Things like interoperability, you're not allowed to self-reference, you have to have transparent terms and services, so they might force you to share more information than you do. You cannot leverage your power is also one of the things in the bill. So, for example, there might be a prohibition on tying services together, so offering services as one product. They are, to some extent, the same obligations, but they don't apply automatically. And so this puts a lot of pressure on the competition authority in the UK, once they have designated the companies, to actually determine which companies they think should apply with which obligations. And the argument in the UK was that that would give not just more flexibility for the authority, but also it would allow them to tailor to the particular circumstances of a company. Because there is a fear, and I think it's a right fear, that the EU bill has all these obligations, but perhaps we don't necessarily need this for every company. There might be different problems for different companies. Do we have the same concerns when we use Instagram, for example, than when we use the Google search engine? And to be fair to the EU bill, they did try to make that difference in the bill, because for some obligations, they'll say this only applies to search engines. So for example, for search ranking, they'll say this is an obligation that only applies to search engines. But of course, that really builds it already into the EU bill, what should be done, which means that the flexibility is not there. If the EU wants to change something, if they see, for example, that Facebook starts a search engine and it's not like a Google search engine, it's a different product, but it has similar rationale, they can't go and adapt they have to adapt the bill if they want to create a new obligation that falls somewhere in the middle. Whereas the UK does not have to do that. It can say, okay, now you are doing the service. We can have a conversation with you about where you fall in the UK bill. Another really interesting difference. Do you remember I told you in Europe there is a fear that focusing on market power will not help us go after these companies? So in the European Union's bill, market power is not mentioned. Dominance is not required. You designate based on certain presumptions that you are an important company that is important to connect businesses and consumers. There are presumptions for finding that you are an important company. There's quantitative presumptions, but these are not the only ones. You can also have qualitative assessments. But market power is not part of it. In the UK, market power is the wording. Not only does the company have to have market power, it has to have substantial entrenched market power in addition to a strategic position between businesses and consumers. What this means to me is that we're really looking at competition plus, right? Because we're still looking at the dominance idea. Although in the recent guidance that the Competition Authority in the UK gave, they said, no, don't worry, this is not dominance. Okay. But it doesn't tell us what exactly it is. Maybe it's a little bit like telecoms regulation, where you have substantial power. But even in telecoms regulation, they ended up using the dominance inspiration from competition law as their inspiration for finding that there was this kind of position to apply telecom regulation. So it's not clear to me whether or not we're just doing like a dominance with extra conditions attached to it in the UK. But the Competition Authority says, no, don't worry. We are not bound by the court decision. We don't have to follow competition jurisprudence to find that there is a company with substantial and entrenched market power. So maybe all it does is release the Competition Authority from having to follow previous law. I think that might be the benefit for the Competition Authority. They can reinterpret and start from scratch if they want to, although there will be limits because the wording market power is a wording we all know. And also, there is a minimum requirement of a minimum amount of income, which means that smaller companies that don't have as much income in the UK, they are not caught, which I think is an interesting and a good thing to do because they're trying to say this really is about going after the big companies, right? Now, we haven't had designations yet in the UK, but ultimately it comes to the same companies, right? I don't think anyone is thinking that they're trying to go after a small local company. They are really going to go after Google, Amazon, Facebook, Microsoft, maybe TikTok, because both in the EU and the UK, it doesn't matter whether this is a company that is from the EU or the UK. All that matters is that they supply to consumers in those countries. And so you could go after any company from anywhere in the world if it is big enough and has an impact on consumers there. Another very, very, very important difference is that under the UK bill, you can defend yourself. If you are Google, you can bring a defense. Now, in the EU, there is no defense, right? There is a little bit of an opportunity that if something really bad happens to you, you can temporarily suspend your obligations under things you couldn't control. But really, it's never going to happen. But the UK bill gives you an opportunity to defend your conduct, and it sounds remarkably similar to what we already have in competition law. It's called the countervailing benefits exception. Basically, if your service benefits consumers and the conduct that you are adopting benefits consumers, then you can defend the conduct. You can go to the UK Competition Authority and say, look, you're telling me that I have to change the way I do things. What consumers benefit from what I do? Now, of course, it's not enough to just say they benefit. You have to show that the benefit is more important than the harm, the problem, right? You have to show that the conduct is necessary to get the benefits to consumers. But ultimately, what does that change about competition law? Perhaps maybe one change is that it's not about efficiency, it's broader. It's consumer benefits, which could be a much larger objective justification, a much larger defense than the really narrow efficiency. But in Europe, we've never been that obsessed with a very small interpretation of efficiency. We've always interpreted efficiency much larger than in the United States, for example. So to me, this is not such a big difference from what we already have. So it's going to be really interesting to see what happens with the defense, because in the EU, defense is not possible. So what happens if a company adopts a certain conduct in the EU and in the UK? And in the UK, it can say, oh, actually, this conduct is good for consumers. So the Competition Authority in the UK says, yes, fine, you can continue. But in the EU, they say, we don't care that it's good for consumers. You still cannot do it. Does that mean the company will continue doing it in the UK, but not in the EU? I think this goes to a larger point, which is that the United Kingdom, which I love, I live there and I work there, likes to think that they have more power than they do. I really, really doubt that a company will have such incentive to do things differently in the United Kingdom from in the EU. We are literally next to each other. The EU's consumer base is much, much bigger. Why would they make extra costs to do something different for a smaller amount of consumers? But I'm not so sure, but maybe I'm wrong. Maybe the UK has more power than we think they do. But if they did, right, if the approach in the UK is different, if Facebook offers a different service in the EU than the UK, is that good? Do you like a service that is fragmented, that is different? The moment you step across the border, it takes me less than 2 hours to go from where my mother lives in Belgium to London. Do I want to suddenly have a different service when I cross that border? I am not sure. So I think this is an important question to ask. The last thing that it does is that it's both the EU and the UK create a new merger regime for digital markets. From now on, all mergers, no matter how big, need to be notified. This is really about making sure we don't miss the killer acquisitions, right? We're very concerned, I think, not just in Europe, that some companies were bought by big platforms, and we didn't realize that they were important because they were smaller, they didn't cost that much, and they fell under our notification system. Now this will not happen again. Now every merger has to be notified to the UK and EU authorities. So this is a big difference. Ultimately, I think whether the UK system is different from the EU might be a silly question. And I think this is important for global international discussions about regulation of digital markets, because divergence in the regulation of digital markets is going to be problematic, right? If I am Google, I will benefit from having different rules everywhere. I know that we like to talk about legal certainty, but I think I will benefit from having different rules everywhere because I can leverage that, right? I can say, well, you're making me do something in the UK, but I'm sorry, in the EU they're doing it like this. And you can come to Brazil where they're thinking of regulating digital markets and say, I really want to help you. I really want to, but I have to already abide by the EU standards. And I think by doing that, all of us will have different lower levels of power to do something about these big companies, because they will be able to say, well, what you're asking me to do is just not possible because I have to do different things everywhere. And so I think we have a problem currently in the world that we're all trying to do something about these companies, but we don't have a unified view on what we're going to do and how we are going to do it. We will see what happens in the UK in the next month. Maybe they are brilliant. Maybe I will learn loads of lessons from how it is happening. But I am worried that de facto, the regulation that counts is the EU regulation. It was the first to come out. It is already enforced. The companies are already changing their business models to comply with them. So at this point, is everything else too late? And if that is the case, then we should be worried, because I think there are significant disadvantages to the EU system, where there isn't really that much conversation about the benefits that these services bring to consumers. And there are some really intense interventions in how these businesses work. And so the rest of the world doesn't really have that much of a say in what we want these companies to look like, if the de facto way of doing it is the European bill. Then the rest of the world just has to swallow it. Is basically what it's down to now, which I think is democratically a problem, but it's also a problem because the experience in Brazil of WhatsApp, as I found out in the last few days, is not the same experience as the European experience of WhatsApp. And so I think this is an important question, but I would love to have a discussion with you about it. So I'll stop here and let you come in and ask me any questions you want about competition law, digital regulation, anything, UK, EU.
Perfect, Professor Magali. Thank you so much. I think, in my opinion, I have several notes here for you. And as I know everybody wants to, share some views and also have this opportunity to, share ideas with you. I will start with my colleague, Professor Gabriel Lochagin. He's also professor, antitrust professor, and he's doing a great job, also being the supervisor of great researchers in our university. So, Professor Gabriel, the floor is yours.
Thank you. Thank you, Juliana, again. Thank you very much, Magali, for a very thoughtful presentation. You made a very clear point on the differences between European Union and UK law applying to digital markets. And I would also have many questions, some of them doubts actually about how the UK system works, and another part would be some remarks. My first objective question, I would say so, if I could say so, is if you can already organize the responses of the UK authority, competition authority, to abusive dominance in digital markets. So what are the remedies? What are the sanctions that have already been applied? So I was curious to listen to your perspective on the work that has been done by the authority, if you can organize a certain rationality in it. So this is an objective question. Another one is more of a remark, a comparison that you provoked in the beginning of your presentation between UK law and the Brazilian rationale for antitrust. I would say that we're closer when it comes to abusive dominance control to UK than to UE, in the sense that we can't dodge market dominance analysis. If there's a case for misconduct of a great player in digital markets, the policies of antitrust authority would have to make a clear point that there is at least a probability of abusive dominance. Of course, of market power conducting to abusive dominance. Of course, we have a new data protection law concerning how the conduct of digital market players would have to be put forward. But anyway, I wouldn't say that our data protection law is in any case concerned with competition. I think it's focused on transparency. It's focused on the protection of data from consumers and from users and so on. So Juliana could explain it much better than I can. Of course, she's the authority here on Brazilian law, but I have the impression that we would find the same sort of trouble in trying to apply market definition rules to antitrust control or to dominance control of digital markets. For example, we would have to demonstrate that data controlling is a kind of entry barrier and so on. There should be a strong economic case showing that there is at least a strong probability of achieving anti-competitive results in the market. So there's a great opportunity for dialogue for the challenges of UK and Brazil, since, in my opinion at least, it's an open discussion, of course, we still would have to apply economic tools to demonstrate the reasonability of market conduct in digital markets, right? So these are my remarks. I try to do my best to make my points clear, but in any case, I would be very interested in your answers. Thank you for a presentation again, Magali.
I'll start with the last one first. Actually, I'll just mix them all up. Shortcuts is really the answer here, right? So anti-competitive effects has been the main problem for a lot of these cases. Now, in both the EU and the UK, you can go after both exclusionary abuse and exploitative abuse. We have clear legal and economic tests for exclusion. We are developing more tests for exploitation. But in the UK, exploitation, so the use of power to harm your trading partners, is something that they do, and they do many cases, mostly on excessive pricing. So if your price is too high, you can be said to abuse your dominance. And there, what is an anti-competitive effect is a bit tenuous, right? So it's not really about the effect on the market, it's about the consequences of a market that is already not working well. And I think this is really what is happening with these bills. The assumption is that there are anti-competitive effects. This is the part that I think in both the EU and the UK is kind of being removed. You don't need to prove it. But the main difference is that these effects do come back in the UK bill later on, because the conduct requirements that the competition authority imposes have to be proportionate to a particular harm. And so in a way, the competition authority will have to some extent, explain why the conduct requirement they're imposing is satisfying, really is doing what they're supposed to do. But remember that the objectives are bigger than just harm to competition. It's fair dealing, open choices, trust and transparency, which is far bigger than our normal harm to competition standard. So I think although the UK has more still of a look-to effect and a potential defense of consumer benefits, the objectives that they are pursuing are bigger, which means that I think this is not going to be as much of a problem. And this is potentially really across Europe, I think, but also across the world, the lesson. Are we really fighting the good fight with our harm to competition standard? Is a focus on efficiency, a focus on exclusion of competitors that has an effect on the market as a whole, is that really the main worry? Because if we're honest, what are all the discussions about big tech really about? They're about the feeling that we are worried about having a few companies that are in charge of really what is the essential infrastructure of our life. But they might be vigorously efficient, vigorously innovative. They might be producing really good products, but I don't think that is the concern anymore. And I think you see this. So you asked me about cases in the UK. There were in the EU, there were quite a few cases. In the UK as well, there were quite a few cases. So the Competition Authority, for example, has investigated the use of data on Amazon to basically give benefits to its own products and to sellers that use its services over third-party sellers. There have been investigations into the Apple Play Store, so whether the access to the Play Store, to the App Store, is making it more difficult for smaller companies to offer their apps to consumers. Actually, most of the big tech companies have been under investigation in the EU and the UK for years now. But I think what this points out is that in both the EU and the UK, the remedies imposed tended to be commitments, so questions to change, requests to change behavior. So stop using data in a particular way, or don't, in the EU, for example, for Android phones, you could no longer tie the search engine to the apps. Stop tying, stop combining and giving no choice about which search engine you see on the phone. Did it change anything? Did we have consumers have a different perspective and a different experience of these services? I think the answer is no, right? And so, although the traditional competition tools were used extensively, there's a feeling that they weren't enough. And that's what it comes down to. I think that's why it's good to remove these things from competition law and make it into regulation, because competition law isn't supposed to deal with these kind of imbalances in power, concerns about bigness. That is not a competition problem, right? It's a regulation problem. Every time we've had a concern that companies got too big, we have regulated. We haven't used competition law. It's not designed to do that. And so I think it's good that there is regulation. The data protection one is interesting, I think, because in the EU, data protection laws were created to protect consumers. But really, the ultimate objective, I think, is that there was a concern that these companies are getting too big, and that the violation of our privacy is a symptom of the fact that they are too big. Not the privacy alone isn't the issue. It's that the reason our privacy is gone is because these companies are too powerful. So I do think there's a connection with competition there. There has been from the start in Europe. And so it's not surprising that there is a lot of discussion about the relation between privacy and competition here. So yeah, I hope that answered your question.
It was great. Thank you very much.
Thank you, Professor Gabriel. Thank you, Professor Magali. I think also Professor Eduardo, he wants to share some views here. So Eduardo, you have the floor here.
Or after the coffee. Okay, well, first of all, congratulations to you, Juliana and Gabriel, for such an amazing, short, organized event in so many places and with so great people. And congratulations. And Professor Magali, pleasure to see you. Congratulations for all what you have done so far to competition and to regulation. And it's I can say I'm very glad to have you in our country. Thank you. Well, I will try to be I will be very concise and just to try to aggregate a little value to this amazing conversation. And I will take from what Professor Magali just mentioned about who we're fighting against, right? But I would not elaborate on the enemy, but on the defenders. And who are the defenders? And from this point of view, I would ask Magali if you could present to us what is the legal competence design of the UK authority, you know. And why I'm asking that? Because here in many places we maybe, and I can tell about Brazil, but I'm sure you can verify what I'm going to say in other places. Here, what we see sometimes is not a real threat against consumers, but a threat against the regulator. What am I trying to say? A threat to the importance or to the necessity of its existence, you know. So regulators, like publishers of non-wished subjects, they are always trying to present themselves as necessary, you know, important in bringing, and that they deal with the most important matters in the country. So they need attention, they need budget, so they need power, right? And I see clearly this discussion, this dilemma, if I may, when we talk about regulating platforms and applying competition rules to that, you know. And maybe the real cause of this, let's say, dilemma or problematic is derived from the fact that we have like a very narrow design of legal competence. In Brazil, we have only one regulator that deals with competition, CADE, period. And competition, that's whatsoever is that CADE do. And we have other regulator. I mean, I cannot say regulator, but I would borrow this this terminology just to put everybody on the same page. But we have other public body that deals with consumer affairs, right? And we have other body that deals with data protection. So just for this, just because of this separation, sometimes we see like important matters of data protection calling the attention of the competition authority. Why? Because they need to be important. Sometimes we see huge consumer affairs problems calling the attention of the competition problem, the competition agency, or the data protection agency. Or sometimes it calls the attention of all other bodies that are never involved, they are never expert to this subject matters, like the public prosecution office, for example, So it ends up creating a big mess of regulators. And what is worse, this mess of regulators trying to be the head of the matter, so to speak, creates another problem that's in my opinion is a little more dangerous than the first one. That is, it calls the attention of the politicians. So it becomes a political active to explore these hypothetical threats against society, and the rest of the story, right? So in a nutshell, I just explained to you, Magali, what happens here in Brazil. How the UK deals with such a problem if it exists in the UK. Sorry. Thank you very much and congratulations again.
These are really important points, Eduardo, and I think these are problems everywhere. And so I don't think Brazil is unique, but I do think the UK has a different system. And so there are some differences. So the structure of competition enforcement in the UK, you have the competition authority, but sectoral regulators also have competition powers. And that forces the competition authority and the sectoral regulator, for example, telecom or the financial industry regulator, to work together on important matters. So there is less rivalry because they're used to cooperation with each other. And so there's a bit more clarity on how you cooperate, but also what happens if a matter is a competition matter and also sectoral matter. So I think it's actually fairly well organized in the UK, perhaps better organized than in the EU, because the EU has not just what is in essence the federal level and all the different member states, all the different countries, whereas the UK is only one entity and the rules are quite well defined. The UK's regulatory system is fascinating because it is completely based on cooperation between regulators. So when it came to digital markets regulation, there was this creation of a cooperation forum between regulators. And so this idea of, obviously there is still this idea that one authority wants to have more power and wants to be the one to get the powers in the new bill, but the conversation happens all the time. So I invited, for example, a couple of months ago, the different regulators to come and talk to us at our research center. And they were so used to talking with each other. They were actually quite, there was a little bit of kind of rivalry in their discussions, but they were willing to say, okay, maybe this isn't what I am supposed to be doing. Maybe this is for the communications regulator, not for the competition authority to deal with. And I think that's fascinating. And I think this is better in the UK than in the EU. And partially that's because there is less political involvement in the authorities in the UK than in the EU. In the EU, the competition authority is part of the European Commission. And the European Commission, although it has different branches which are supposed to be independent, our competition commissioner is a politician, right? And so you have a very good, really very good technical team in the European Commission, you have very good legal team, very good team of economists, but this political view will always have some impact because you have the politicians that are involved and because the competition authority is part of the larger political body. In the UK, this is not the case. They are very clear that this has to be an independent body, subject to judicial review, but not a political body. We also have a specialized appeals court for competition cases. So the competition authority in the UK, their decisions go to a competition judge group, right? So the expertise is very high. It's a completely different system. And to me, it made entire sense for the UK bill of digital regulation to be part of the same kind of structure of an independent authority that gets reviewed by a specialized tribunal. But I am always a big proponent of having less politics, but the democratic legitimacy is a problem. Ultimately in Europe, and I don't know if it's the same in Brazil, and I'd be interested, but in Europe, I think there is a general not anti, but a general sensation that there is an enemy out there, right? And so if you have a completely independent, neutral authority and the bills get passed and they're completely technocratic and decided by experts, that makes it really difficult to say to the general population of the European Union, look, we're fixing a problem that you actually care about. Because as much as I love competition law, I think in Europe, this is different now. Say 10 years ago, no one in my family understood what competition law meant. Now in Europe, everybody knows what competition law is, because suddenly the idea of going after the big tech companies has become a politically popular thing to do. In the UK, there is a feeling that the bill was passed without much discussion with the general stakeholders in the world. But interestingly, the UK bill now has loads of mandatory requirements for the competition authority to consult with the public. And I think this is because they realized that there was a general feeling that the population in the UK hadn't been involved enough. But I don't know what that will mean in practice, because do we all have the same problems? I really love using WhatsApp, I do. And I am very concerned about my privacy. I've always been concerned about my privacy. But am I concerned enough to give up the service? Probably not, but I am concerned enough to pay for it if I have to. But that's a privileged position, right? So, the Facebook asking, I'm not going to convert, but let's say Facebook asking 1,000 real a month for you to use the service and not collect your data. That's something I am willing to do, but is that something you are willing to do? We don't all agree, I think, on what the actual problems are. And so it is super, super easy for it to become a political, arbitrary, power-grabbing problem. Because if the problem isn't clearly defined, then I can pretend that I am fixing your problem because you haven't told me what your problem is. And so I can tell you that I am giving you a solution. And if it makes me more powerful in the meantime, then that's great. And I think this is a problem everywhere, not just in Brazil, everywhere. But there are differences in the way the European Union and the UK try to deal with that. So I don't know if this solves the question you raised, but I think it's yeah.
Sure. I would thank you very much. Actually, sure, yes, you answered, and I would love to arrange for another discussion, not today, but on this competition specialized court, a tribunal in the UK, because this is my dream for Brazil. I dream about it every day, and as much as I go to courts here, I dream more about having a specialized competition tribunal, and we should definitely talk a little more about it, Magali, and maybe thinking of preparing some short event on that. Okay, so let's talk about it later. And congratulations, thank you very much, Professor Juliana, Professor Gabriel, and all you guys that are participating. Dario, I can see. Thank you very much.
Thank you, Eduardo. I would like to ask you if someone else would like to interact a little bit with Professor Magali.
Yes, if I can start.
Okay. Thank you, Dario.
Thank you. Thank Professor Juliana, Magali once again, Professor Eduardo, Professor Gabriel. Didn't know you, but it's a pleasure to be here. So, Magali, my question for you is about the cooperation and how the DMA is working with other competition authorities. So I know that the DMA is supposed to be enforced only by the European Commission, although and like the European authority, the other NCAs could not make a judgment that some kinds is contrary to a decision by the European Commission. So my first question is, so what we have now in Europe is that we have Germany that has Section 19A, that is some kind of extensive digital market regulations. So we have one example of a country that has some kind of DMA Act law. And so with this scenario, we have some kind of cooperation, while with all the other countries that do not have Section 19A or a DMA-alike bill, what is the difference between like the cooperation or like the relation between Germany and the European Commission and all the other countries that do not have this kind of bill and the European Commission? So this is my first question. And my second question now, it's related to abuse of dominance cases. So it is said that the DMA is not supposed to replace the abuse of dominance cases. So 101 and 102 it still applies to the cases, although they have in Article 40, no, which article, I don't know, 40, 38, 37, 38, to have some need of cooperation with the NCAs, and now we are seeing some kind of MOU being signed by the competition authorities and the European Commission regarding this kind of cooperation on the DMA. However, which I do not like really get it until now is since the DMA will not have some kind of consequence to the application of abuse of dominant cases, which kind of cooperation does these kind of MOUs are supposed to have, in the sense that the countries, the NCAs, were already obliged to apply 101 and 102 whenever they are facing some kind of abuse of dominant cases inside of their jurisdiction. And just to close up here, to wrapping up, so we had like the decision yesterday, 2 days ago, for the booking.com in Spain, big huge fine, and the decision, from what I read, it was like no one was kind of sure if the Spanish Competition Authority would use this kind of the Article 38 to also like do some kind of relation, because they also just opened an investigation against Apple, which is kind of similar to the investigation that the European Commission is doing with the within the DMA against Apple for non-compliance of the obligations of the DMA. So my question is, like, if you can like a bit more and try to summarize this kind of coordination between the NCAs and the European Commission for the abuse of dominant cases, but also for the application of the ex-ante regulation and how it's working, and I don't know, your views about it. Thank you.
Okay. So this is complicated, right? It's so complicated that there are quite a few academics doing nothing but writing papers about this now. And the reason for that is that it was already complicated before the DMA. So before the EU had its own digital market bill, there was already some challenges with the cooperation between the EU level and the national level, just purely on competition law, because under the current rules, or the competition law rules, the member states, the countries like Germany or Spain, their authorities, when they apply their national competition law, which they have, so they have their own national versions of competition law, have to apply EU competition law as well. And so the EU standards, if the case isn't a purely national case, meaning that if there is an impact on more than just their country, So if I am in France, the French authority, if the conduct also has an impact on German consumers, then I have to apply EU competition law, not just French competition law. In theory, that means that the EU principles are the ones that matter. You have to align your national law to EU law. But there are exceptions to this. Even before digital markets, there were exceptions that allowed the member states, the countries of Europe, to have stricter competition laws when it was about abusive dominance. So cartels have to be the same as the EU principles, but for things like abusive dominance, some countries have abusive economic dependence. So you don't have to show market power, but if you have a situation of dependence, you can impose a decision. Or they have different theories of harm than the EU. This obviously creates a risk of divergence. And so there was an attempt at coming up with a system on how to reconcile these conflicts. But in practice, my opinion is that in practice, the European Union has chosen most of the time not to intervene when a member state does something that is different from the EU principles, because for the most part, they didn't think it created massive problems in the economy, and it was not a priority to solve the divergences. And before digital markets, this is kind of okay, because, you know, if you've got a supermarket case, the supermarket might cross the borders, but they will still be physically mostly restrained. There will be territorial limits to the effect of a decision of a Spanish authority, for example. When digital markets cases started, so even before regulation, I think the problems really started happening, because if you regulate Facebook, there's no territorial limit to that, right? That has an impact across the European Union. And you really saw that different countries, even countries who didn't have different competition rules before, decided to create more different rules. In Belgium, for example, they created an abusive economic dependence provision. They didn't have that before, but they decided that at digital markets, it was time to do it. So you start getting cases that are different. And normally in Europe, these problems are solved because there are regular meetings of all the national authorities together, where to some extent they negotiate, well, I'm doing a case on this particular company. I see you're already doing a case. Maybe I will wait to see what you have done before I bring my own case. But in digital markets, I think there was a bit of a temptation to be the first, to be the leader. And so everybody was trying to do their cases, you know? This problem already existed, and then the DMA came. And the reason I think the European Commission said under the Digital Markets Act, we are going to be the main enforcers, the only enforcers, is because they saw that there was going to be a problem if all the different countries could have their different applications. But this was politically not very popular, because in Germany, which is a very strong country in the European Union, Germany had already adopted its new provision that was kind of like the DMA, Section 19A. And so they said, well, we already have a provision. Are you telling me that I cannot use my provision? I've already made one, and now you're telling me I cannot use it. This is just not okay. And so exceptions were being brought in. Well, you can have stricter. Oh no. So the German provision can remain because the German provision is considered to be different from the DMA, stricter or of a different objective, and so it can remain. And then they added, and also the member state authorities will be our enforcers, not because they can enforce the DMA, but because they can gather information for us. They can investigate conduct for us if we ask them to. So then suddenly you have this. Then the European Commission said, please send us people from the national authorities to come help us with these cases. So even though the European Commission is the only enforcer of the DMA in practice, nothing has changed. All these other rules can still be applied to the same conduct. And the member states feel, because they've been given a little bit, that they really should be involved in the enforcement of the DMA. So why can't the Spanish authority do what it's doing? Well, it can adopt its own different diverging rules to the same conduct as the DMA. And so you need cooperation, you need some kind of memorandum, because we are in a really chaotic situation now. maybe chaos is not a bad thing at the start when you're trying to figure out the best approaches to dealing with these conducts. But at some point, I think we need to come together and have a clear discussion about who is in charge and who sets the standards, because currently that's not very clear. And if you add to this that you can now also go to national courts for damages, the mess is only starting, right? We will have loads of cases. And I have a colleague who likes to say that the best thing we can have in the EU is experimentation. If you experiment long enough, eventually you will find the right solution. And in competition, I think it kind of worked, right? So before digital markets, we would let the UK came up with really cool standards for determining when a price of a medicine was too high. And that was then replicated in other countries, eventually influences the EU. But in digital markets, experimentation just leads to like 100 different versions of WhatsApp. And I really do not want 100 different versions of WhatsApp. So that's why I hope that answers the question why we need memoranda, because even though in practice the European Commission is the enforcer, you also have all the other different national provisions that still apply.
Thank you, Professor Magali. Thank you, Dario, for your questions and observations. I would like also here to open this space if somebody else wants to add some comments or share more doubts to Professor Magali. I think it's the right time. If you don't, I just have one question related to the concept of fairness, because this is something that for us in Brazil is different, right? And I think that maybe you can add for us some comments related to this concept. How are you dealing with this concept?
Okay, the concept of fairness. The concept of fairness has been in EU competition law since the beginning. That doesn't mean that we know what it means, right? We've had it since the beginning, but we were very bad at defining it. When I teach my students, I have a swear jar, right? Instead of swearing, if you use the word fairness, you have to put money in the tip, because I think it is the most problematic and useless word in competition law. So they're not allowed to use the word fairness. I also think it's a cheat word, right? It's a cheat word because if you want to make what you're doing sound good, but you don't actually understand what you're doing, you can just say that you're going after something because it's unfair. End of the discussion because you sound good. So that's why I don't like them using the word fairness. But it's there, and it is there now more with the Digital Markets Act. So fairness has a specific meaning in competition law only when we're talking about excessive pricing. And even there, it is very badly defined. But there is a relationship between the prices charged by other companies and also whether or not it goes beyond the economic value of the product to a consumer. It's the only time the court has actually tried to define fairness. And it is not useful anywhere else than excessive pricing. In the Digital Markets Act, however, fairness is the main objective. Fairness and contestability. Fairness, to me, belongs not in competition law, but in things like unfair trading practices, consumer protection law. That's where I think the word fairness belongs. But I now have no choice but to accept it is here because it is in the Digital Markets Bill. But what I do like about it is that it has been defined in the DMA as an imbalance in bargaining position, right? So an imbalance in bargaining positions that allows you to impose unreasonable terms. So it's slightly less vague than it was before. Still not very useful, because what is an unreasonable term is still a bit vague. There are a lot of academics that write about fairness in competition law, and some of them really like it, but I don't think it's a very useful tool for enforcement. It's, I think, a way of justifying your law politically, democratically, but I don't think it's an enforcement tool, if that makes sense, right? obviously you go after particular conduct because it is unfair. Law is supposed to be about fairness. But that doesn't allow me to say, well, your conduct is unfair. It's a bit like when you have young children. When my little sister was young, for example, and she did something wrong and I punished her and she told me I was being unfair. Your opinion, you might feel unhappy about this conduct. You might feel unhappy about the fact that I'm punishing you, but you haven't explained to me why. And because you cannot explain to me why you are saying it is unfair, that's how I feel about that word. But this is my opinion. There are loads of people who think fairness is a very good word. I don't like it.
Thank you, Professor Magali. I think we are just running. We're going to have this nice conversation about the same topic with FGV Rio. Here we have students from the University of São Paulo that they were also invited to this meeting with Professor Nicolas Ingales. So I can invite you to follow us in a couple of minutes. In fact, you have time to have your coffee and also stay a little bit away from this topic, thinking about all the things we already discussed here, and then come back again. But I would really like you I would like to say to you, Professor Magali, that this is a very important hot topic here in Brazil. There are many things ongoing, and we usually think that everything that is happening outside Brazil are better than here in Brazil. This is something that we need to really work on inside, the universities, because I think we are all in the same page now. It was not like in the beginning of antitrust law, for example. That was really important to follow the footsteps from more mature jurisdictions, and also follow the OECD best practices. I think we did a real good job here in Brazil. That's why CADE is so well known outside not Latin America, but worldwide. But I think related to this kind of topic, we are all in the same page, and we must consider that we can also disagree in a way that we can build here our bills in a better way than we used to be in the past, especially because I am still not sure yet if we have here all the tools that we need now to have this kind of bill. But this is a very particular thing that I'm sharing, considering my views today. And that's why it's so important to understand a little more the experiences outside. And I think for us, it's a very valuable experience that you're sharing in this moment. So thank you so much for your time, for your energy, for your papers here. I think we own, everyone in this room read your paper. And of course, if you all want to follow this discussion, the same topic we will have now with the researchers from FGV. And I finally open here for the last remarks from Professor Gabriel, and then I go back again to Professor Magali.
Thank you, Magali. I'd just like to thank you for sharing so much with us. Your time, your papers, your thoughts. It's been very useful and inspiring. Thank you very much. And I see you next week.
Thank you. I look forward to seeing you.
So Magali needs to prepare herself, right? Because she's going to visit the Brazilian Californian city. If you don't know, this is the way they call Ribeirão Preto, but without any beach.
I thought you were talking about Rio there for a second, because the beaches, Juliana, the beaches.
Yeah, we missed the beaches. But thank you again. And I thank you all here inside this room. See you soon. And of course, you're all invited to be in presence to meet personally Professor Magali, because besides everything that she shows she is also a very smart and funny person. So this is a part that you will miss if you just keep online, okay? So thank you so much. I'm going to end the session here.